everybody, welcome to this session of the Masterclass Group Coaching Call. This is where you get your opportunity to speak to me. I can either unmute you, you can type a question into the box, and you can ask away. This is your opportunity by being a member of the Masterclass Elite program to get time with me. If anybody needs anything special, we can do that offline. Make sure that you're all taken care of. That's the idea behind the Masterclass program. So, and as always, I state this disclaimer here that I am an attorney. I am not your attorney. Always seek competent legal counsel in the jurisdiction in which you are looking to do business or you need to do business in. I most likely will not be your attorney in those scenarios. I act more as a consultant in order to protect myself and my firm from the unlicensed practice of law in other jurisdictions. All right, so this, for those of you that are new to the Masterclass program, welcome. There's a ton of information on the membership site. You can spend a month full of Sundays going through all that stuff and not hit the same things twice. The purpose of the group coaching calls is really an open line forum. It was intentionally started or intended to just be open. Anybody want to talk, anybody have any questions, we'll go as long as anybody needs to. And then I found that there were some particular topics that people brought up through the course of the 2 weeks between sessions that I thought would be a good lesson in talking in teaching. So what I've now done is I've kind of made the group coaching call both a teaching call but also an open line call so that I can answer any questions that you have. So if you have questions, type them in. I'll either hit them throughout the course of this discussion or I will save them for the very end and make sure that all questions get answered. All right, so the topic today, I received a question from one of the students regarding how he should structure his entities. And so I decided that that might be a good topic. I think I may have done this before. You might be able to find it on one of the, somewhere in the resources and archives section, but it's good enough to go over it again now that you have me live, if you have any questions about how to do it. But before I get started, oh, wait a minute. Okay. Before I get started, I have to share with you the contents of a phone conversation I just had about an hour ago that got me so angry that I thought I'm going to share this with the class so that you all understand what this business can be like. Now, you all know how I feel about brokers, and you're about to find out why I feel this way about brokers. Now, I was working with a particular student. He sent over a property package that he wanted me to take a look at, and he just sent me the numbers. And I didn't know anything about this property. But I look at this property, and the property had a 29% expense ratio. So I get on the phone with the student, and I said, okay, this, based upon the numbers, this is a Class A property in a low-cost area, correct? He goes, no, this is a C-class property in a kind of an expensive area. I said, well, the numbers are bogus then. He goes, how can you figure that out? And it's based upon the expense ratio. Now, I use this as a very rough rule of thumb, and I go through this expense ratio in depth in the 4th or 5th month lesson of the master class where I talk about understanding financial statements. But the expense ratio in this case is 29% for a C-class property. That cannot be. So I got on the phone with the broker, and he tells me, well, yeah, you know, it's a self-managed property. That's why the expenses are 29%. And we, in our pro forma, bumped them up to 35% expense ratio. I said, okay, fine. But even a Class C property anywhere tends not to be able to be run at a 35% expense ratio. Well, the reason why we're able to do it is because we have low insurance costs and we have low taxes, not like what you have out there on the coasts. We have a much, it's a lot easier. And I think to myself, no, this is a ratio. A ratio takes into consideration the ratio of expenses to revenue. And so as you move around from the coasts, I mean, the ratios are essentially the same. There's a little play in them, but they're essentially the same. So then in the conversation, the broker said that the properties like the one we're looking at in this particular marketplace run at $3,500 per year in expenses. Well, I thought that was great because now I didn't even need a calculator. If they're $3,500 per unit per year in expenses and the expense ratio is 35%, what's the average annual rent? I didn't even need a calculator. All you had to do was stick that number in. You got 2 of the 3 variables, and boom, $10,000. Now you divide that by 12, and what's the average rent in this marketplace to get a 35% expense ratio? Each one of those units needs to be generating $833 per unit per year in rent, per unit per month in rent. And so I asked the $1 million question of the broker. What's the average rents? He told me they were $550. Well, guess what? If that's the case, it cannot be a 35% expense ratio. It just can't be. And then the broker says something like, you're talking in circles right now. Your numbers aren't making any sense. I'm thinking to myself, these aren't my numbers. You just gave them to me. So how can I be off here? And so what you do now is you take the average rent of $550 times 12. That becomes your new denominator. And you put it over the numerator of the $3,500 expenses per year. And what's the actual expense ratio? 55%, which is exactly what I said it should be for a property like this. Not 29%, not 35%, but 55%. And you should have seen the broker get all up in arms. He didn't want to talk to me anymore because I use his numbers against him. I tell you, folks, this is just what you have to deal with when you're dealing with brokers. You just stick to the facts. Nothing emotional. Let's use logic. This is just a numbers game. Let's use the numbers. And as you can see by just doing these numbers, I can't make an offer. I can't tell the student in this class to make an offer based upon a 35% expense ratio. And the numbers just don't make sense. The bank won't allow him to do that. So that's why we look at it this way. Now, for those of you that are really good with numbers and really understand how to tie this whole thing together, you got to understand that this, using the expense ratio the way I did, is very basic, almost sophomore. But it's, as you can see, I quickly was able to figure out that the guy's numbers are bogus. Then what happens is I will break down the numbers even further. I'll take into consideration vacancy rates, possessions, all those other types of things that go towards driving down the revenue, and I'll come up with an actual expense ratio. But just from a quick down and dirty analysis number, that's how I came up with it. So, you know, unfortunately, I had this conversation with the broker, and he wasn't too happy with me. So, you know, so that's kind of why I do it the way I do it. Okay, so I'm just reading some other questions that are coming in. Okay, let's see here. Let's get into our discussion of the legal entities. Now, obviously, I could teach this like a law school class where we talk about all the different types of entities. So let me quickly run through the names. I'm not going to talk to you about what they are, but these are typical forms of entities that that you will see in multifamily ownership. All right, in any type of ownership of any type of business, you'll have a sole proprietorship. Actually, guys, I'll tell you straight up that my father-in-law owns multifamily property in his own name. You might think that's crazy, so do I. But because of the special financing that he got for it, the government required that it be in his name. So there are other methods of ways to protect himself if anything should go wrong, but in that particular case, he had to own the property in his own name. Then you've got partnerships, general partnerships, limited liability partnerships, those types of things, very limited in how you're able to structure them. The rules are very tight. So you just got to be careful if choosing a partnership to run your business is the right thing to do. Now, then you have corporations. You have, and all corporations are the same. All right, they all, from a legal structural standpoint, act the same. They become S corps or C corps when you file a form with the IRS. I believe they're all C corps until you file the S elective form, and then you can take advantage of an S corp, which is nothing more than a pass-through entity. But to get that S corp status, there are requirements, such as it can only be 35 or fewer stockholders. Okay, fine. Those are the different, another type. Now, the point that I want to make, and one that I want to talk about the most today, is pretty much the question that was asked of me of the student, and that is what I like to call the new kid in the block. And I call it the new kid in the block because when I was in law school, this wasn't even an alternative in the Commonwealth of Massachusetts, where I went to law school. So we didn't even learn about these entities when we were way back in the day. And that is the limited liability company, the LLC. All right, now, the first thing I'm going to do is help you to get your nomenclature straight. I don't want you to speak the wrong terms, because when you use the wrong terminology, when you're talking about an LLC, you don't sound like you know what you're doing, okay? Now, the first thing is that there are no stockholders in an LLC. So don't talk about stock. You have members, and the members have not stock, but membership interest. So they have a certain percentage membership interest in the property. All right, so that is the first difference between a corporation and an LLC. So don't say, well, how much stock do you own in the LLC? You own 0 stock in that. You may own the entire LLC, but you own 0 stock in it because an LLC does not have stock. So make sure you get that right. Now, the other thing about, you can have presidents in an LLC. Now, what I mean by that is you have members in an LLC. And hold on a second, guys. Someone is knocking at my door. Hold on. Thanks. Sorry about that, guys. UPS just delivered something for me. Okay, so that is, so you have presidents, and here's the thing. You don't have stockholders, you have members. You can have a member-controlled LLC or a manager-controlled. I'll talk about that more in just a second. But here's something that happened to me early on, and I realized that some people don't quite understand this. I was having this conversation with a particular, she was a bookkeeper, and I told her that this person, for a particular entity that we had set up, this person was the president of the LLC. And she was very quick to tell me that you cannot have presidents of LLCs. And I said, sure you can. She said, no, you cannot have presidents of LLCs. You have managers or you have members. And I said, no, that's not true. She was, that is absolutely true. I know that for a fact. Please don't tell me otherwise. I'm like, okay, let me explain to you. And what I realized is this woman wasn't getting it. When you look at the actual structure of an LLC, you have members, all right? Then you give members, the members then determine who controls the LLC. And it's either a member-controlled LLC where everybody votes like it's a board, or the members choose a manager to run the company. And then you have what's called a manager-controlled LLC. Now, the manager who is in charge of running the LLC can then go and choose someone to be the president if they want, or they don't have to. The manager can control the whole thing. But you can have a whole similar structure of a corporation within the LLC, provided that it falls under the structure of a manager-controlled or a member-controlled LLC. So it really is, the beautiful thing about the LLC is how flexible it is. So yes, you can have the president of the company, just like you have with any other type of company. But it always will have members, and if the members decide to run it as a manager-controlled, you'll have a managing member. All right, so that is how these entities work. Just remember that, and it all goes back to getting the nomenclature right. Now, this is the other thing. Number 4 is, this is the other cool thing about an LLC, is who or what is the managing member. So you can choose, when the members decide who the managing member will be, the managing member can be a person, or it can be another LLC, or I believe it can be a trust as well. It can be another entity. So the way I've set up most of my LLCs is that the managing member is another entity. It provides another level of liability protection and keeps me out of it. So you can always have an entity set up as the managing member of the LLC. So just keep that in mind when you're thinking about how should I structure this deal. Some of the flexibility of the LLC is so unique to the LLC that it doesn't even apply to the to other companies. Other companies do not have this type of flexibility. The LLC does. So let me give you an example. You can create different categories of control. Now, what I mean by that is, typically the way we structure it is there will be different classes of members. All right? Now, the different classes of members may be a Class A, who have total control over the operations of the property, and a Class B that are silent. They have no day-to-day control, they have no voting rights, and they just sit back and wait for the company to make money. Now, those are examples of 2 different categories of control that you can create within the LLC structure by creating different classes. Now, to take that one step further, you can create different categories of classes based upon what people are investing in. Let's say that you have decided you want to give a preferred return to some investors, and then you want to give other investors more equity based upon their contribution, and you want to have a third category of investors who are just the silent, they put cash in, but they're not taking on any additional risk, and so their interest buys a different level. And only the first class gets voting rights, and the third class does not get voting rights, but the middle class can only vote on certain aspects. You can be that type of creative with an LLC structure when you set it up. And obviously, if you're looking to raise private money, all of these things will be clearly labeled in the operating agreement of the LLC. That's the name of the document that governs the LLC. Make sure you get that nomenclature straight too. OA, operating agreement. Don't call it a certificate, a stock certificate. Don't call it a shareholders agreement. It is an operating agreement. So you can create different categories within the operating agreement to solve particular issues. One of the issues that you're going to have to solve potentially is a seller financing issue. I talk about this a lot in my classes. And this is where if you were to go and make an offer to buy the property and you ask for a seller second, and the seller says, sure, I'll provide seller financing. And then you go to the bank and the bank says, okay, this is all fine, well and good, but we're not going to allow seller financing because we don't want you to put any risk on the property. In other words, we don't want you to give anyone else foreclosure rights on the property. And if you give a guy a second mortgage, he's going to have foreclosure rights. And so the first bank says, no, we don't want that. And so you go back to the seller and say, we got a problem. He says, what's the problem? So we can't give you a seller second. We can't secure it with the property. Well, what are you going to do? Well, what you can do is create a separate category of membership interest in the LLC within the operating agreement that looks, acts, and feels like a second mortgage. And we do this a lot. So what we do is we structure that class of membership so that it has all the same rights, title, and interest that a second mortgage holder would have, but it doesn't have any foreclosure rights on the property. Let me give you an example. This guy has a certain term. He gets all of his money back after a certain amount of time, and if he doesn't get all his money back, then he collects more membership interest from people. Or he let me think, what's another thing? He gets certain dividend every year before anybody else gets any distributions. And I'm sorry, I just said something wrong. And here I am telling you all about the correct nomenclature. I just said that a LLC gives out dividends at the end of the year. Only stock companies give dividends. An LLC gives out a membership distribution. Okay? So that's a big nomenclature difference. Make sure that you use that correctly, not like me. Do like I say, not like I just did. Okay, so you can set up that Class C or that whatever class it is of membership interest in the company so that it looks, acts, and feels just like a second mortgage, and you are able to solve all the problems that the bank has just created for you, that the seller wants to have fixed, and you can do it all within the structure of an LLC. Another beautiful thing about the LLC. Now, here is something new. And like I told you when I first started, LLCs are so new, they didn't even exist when I was in law school. Well, they existed other places. They didn't exist in my state. Since that time, they've come up with a new form of an LLC called a series LLC. I wish they had these things back when I was starting my real estate business, because this is exactly the way I would do it. Because right now, the way it works is every year, I have to register or re-register all of my LLCs in Massachusetts. $500 a piece. Pretty heavy money for nothing. For the governor, taking care of the governor. Waste of money. So what they did, certain states, is they came up with a series LLC. Now you have one parent LLC and then sister LLCs below it. And instead of having to pay $500 every time you set up a series LLC, you only do it once. And you can have different entities. Now, if you're buying and selling property, this is a great way to do it, because you don't have to set up a new LLC every time you buy a new property. You can just have a series LLC, and you create a new entity below that one. Same tax, one tax ID number, okay? So let me run through some of this stuff. Liability is incurred by one unit, one of your houses or one of your multifamilies does not cross over and jeopardize assets titled in or allocated to other subsidiary units within the same series LLC. That's perfect. You have one series LLC, and you've got different entities within them, and they're not going to be cross-collateralized or the risk isn't going to be spread across the two properties. They will have that Chinese wall between the two of them. There's a corporate veil between the two, between all of the entities. Now, while the series LLC is attractive for some business owners, the legal separation of assets and liabilities of each series has largely been untested in court. Okay? Certain states have these, certain states don't. We haven't had a lot of case law on it yet. That's how new these things are. But go ahead. Don't use that as a reason why you shouldn't set up a series LLC. I'm just trying to be as clear as I possibly can for you. Now, here's the deal. U.S. states and territories where a series LLC can be formed. The student today asked me, where should he set up his LLC? Should it be in the state that he's doing business in? Should it be in the state where, where it's more beneficial to him? Should it be in his home state? I can't answer that question because there are too many variables involved in answering that question. But let's just use a hypothetical, all right? First off, the LLC does not need to be formed in the state where the property is located. The people who are investing in the LLC can do it right in your home state, and that LLC can go out and buy a property in another state. You will have to register that entity in that foreign state, but as long as you do that, then you're all legal. So, and one of the things in the operating agreement is going to be what we lawyers call a choice of law and a choice of forum provision, which basically states that if you join this LLC and you decide to sue us, you have to sue us where we say it here in this document, and we get to use a particular type of law. So if I own property in Texas, but I set up the LLC here in Massachusetts, then that means that I can then go and I'll set up the choice of form and the choice of law right here in Massachusetts So if you want to sue me on that property in Texas, you've got to come to my backyard. So that's how you want to think about these things when you're deciding where do I want to set up the LLC. That's one of the reasons. So you don't have to do it in the state that you're in. Just check my questions here. Take a brief pause. Okay, good. And just to make sure everybody can still hear me. Okay, I got some more questions. So everybody's hearing me. Good. All right. Now, why doesn't every state have a series LLC option? Are you kidding me? I live in Massachusetts. Why do you think Massachusetts doesn't have a series LLC? Because they would lose a ton of revenue if they did. I got to pay them $500 for every entity. Instead of paying them $500 for all my 9 entities, I got to pay them $500 for all 9. Believe me, they're not out there to do what's right for business. They're not here to help business. But here are the states that offer series LLCs. So any one of these states, you can choose to set up your series LLC, and so let me give you a perfect example. Let's say that Delaware. I want to set it up in Delaware, all right? I can set up my series LLC in Delaware, and all of the entities that I create are Delaware LLCs. Does that mean if I sue, I have to do it in Delaware? No. All you need in Delaware is a registered agent. And believe me, that is a commodity. When you go online to set up your LLC in Delaware, you will be, you just sign up with another website for a registered agent, and they become your agent. You pay them, I don't know, $25, $50, and they become your agent every single year. What that means is if you get sued and somebody has to find you, they're going to go to the registered agent in the jurisdiction that you set up the LLC, and that's considered notice. The service and process is sufficient by giving it to the registered agent. All right. So you set up Delaware as the LLC. Does that mean that you have to go to Delaware courts if you want to get sued? No. You go to the operating agreement. What does the operating agreement say as to the choice of law and the choice of forum? Well, I want to do it here in Massachusetts. Okay, so all of my operating agreements for my Delaware LLCs say that any disputes have to be settled here in the Plymouth County of Massachusetts. I'm good. Okay, now where can I buy property for a Delaware LLC that is domiciled in Massachusetts? You can buy it anywhere. I can buy it in Texas. So I can go to Texas and I can say, okay, we're going to buy that piece of property. Okay, well, who are you? Well, we're ABC 123 LLC. Okay, well, are you registered here in the state of Texas? No. What do I have to do? Here, fill out this form and write us a check. And guess what? You're registered. Oh, okay, that was easy. So now what happens if I get sued in Texas? Well, if you get sued in Texas, they're going to use the Secretary of State as your registered agent to accept process. Okay? And so if you get sued, they can go to the Secretary of State and say, this guy is registered in your state, here's our lawsuit, and then the Secretary of State will send it to you, and that will satisfy the notice requirement of a court case because you did all of those things. So that is how you handle it from different jurisdictions. So you can be incredibly flexible in setting up LLCs. You can be incredibly flexible as to where you want to set up the LLCs, or you can be incredibly flexible as to who owns what and who gets what within an LLC. And I'm telling you, folks, I said early on that this is the entity that I use for all of my properties, but it's the easiest entity to deal with, and it's because of these reasons, because it's so easy to make these things happen. So that's why I love the LLC. All right. Now, let me jump over here to now how to minimize the chances of one series being held liable for liabilities of the entity as a whole or of another series. I'm going to run through these bullets one by one, and let me just say that the bullets, I'm answering this particular question by going through these bullets, but as business owners, you should be doing all of these things anyway. All right, here we go. Each one of your entities should have a separate bank account and to be maintained for each series, okay? Anytime, every property you set up should have a separate bank account. Every separate entity that you have, I call them properties, I mean entity, every separate entity should have its own bank account. Do not commingle funds. All right? I can tell you when I got sued by the SEC, I had everything down perfectly. I never commingled funds. I had separate accounting for every single property. It was so easy to distinguish what money went where, and that is the only way to set things up. Never, never commingle funds. All contracts, deeds, notes, and everything should be signed in the name of the series. All right, just do it in the name of the series. If you don't, you could be opening yourself up for liability problems. You can be giving the courts an opportunity to, as we call it, pierce the corporate veil. If you start to sign things in a different name, like yourself personally, on behalf of the entity, you could run the risk of piercing the corporate veil and losing that liability protection. Now, all loans between series should be properly documented. I'm telling you folks, whenever we have like two properties that are right across the street from each other, similar ownership, one's short on the payroll 1 month, and we have to kind of borrow from one to go to the other, it gets documented. No one ever questions where that money came from or who it's owed to. You've got everything well documented. And I recommend you always do the same. Any transactions between series should be conducted in an arm's length manner at fair market prices using appraisals. Because think about it. You could have a series LLC with 10 sister LLCs below it, 10 separate businesses, 10 separate properties, and 25 different investors in all of those entities. One investor may own one LLC, 3 investors could own another, 7 could own the third, and you've got all different entities being owned by different people with different requirements. So what that means is if you have any type of self-dealing, or if one entity dealing with another, it's not on an arm's length basis, you could be setting yourself up for lawsuits going down the road from investors. If you have some type of a deal where your exit strategy is such that you're going to refinance out those investors, pay them back, and then buy out their shares, and you own the property yourself. If that's what your exit strategy is, you had better have all of that in writing, and you had better document how you're going to calculate out the value of the property. Because what investors might say is, great, you gave me my money back, but that property is now worth a lot more than when we bought it. I want more. And you'll say, well, no, it's not worth that much. Okay, prove it. Now it becomes your responsibility to make sure that the valuation of that purchase is done correctly. If you fail to do so, it could be viewed as failing the arm's length transaction test, and they could come back at you as self-dealing, and you could get yourself into trouble. So always be very careful of that. Whenever I hear people talking about, well, I'm going to refinance these people out, I'm going to pay them back, I think, okay, what do you have in writing? What have you shared with these people that that's what you're looking to do? Because that's a great way to do it. But if you don't have everybody sign off on it and have everybody agree to the valuation process, you could be opening yourself up to some problems. Now, have each series file a fictitious business name statement in each county where it owns property. This is what I was talking about signing on as a foreign entity in Texas in that example I gave. Each series should have its own name, and the filing should be emphasizing the ownership of that series. This is to put creditors on notice that there's a different ownership structure. You always want to do this. You always want to put everybody on notice as to who you are and what you're doing. You do that by filing those forms either in the county. Here in Massachusetts, it could be in an individual city, or definitely with the Secretary of State's office, usually where you have to file foreign entity forms. Keep the assets and the operations of each series separate from the other series. each asset should be owned solely by one series, okay? Don't commingle ownership. Just understand that that one ownership structure, there should be one operating agreement for each LLC, and that whoever signs off is listed on the Schedule A on the operating agreement are the people that own that particular entity. So make sure that you do that. And then, of course, I know this is kind of eerie, make sure each series is adequately capitalized. Any business should be adequately capitalized. So always make sure that that's the case. So that answers that one student's question regarding entities and entity structures. Hopefully, I hit upon everything. So let me blow up the questions here. Now I'm going to turn it over to the different questions. I'm going to try to hear. Can still hear you. Okay, thanks, Vance. All right. So let's see. Does the bank holding the first mortgage require you to show them the operating agreement, which would disclose the potential membership distribution to the investors who otherwise probably would have held a second mortgage? Okay. Mike is asking, do you disclose the information? Okay, let me explain to you, Mike, how it works and lay it all out here for you. What happens is, and this is how it happened for us in one particular deal, is when we went and we made the offer in the letter of intent, we asked for a second mortgage. The seller came back and accepted our LOI terms, which included the second mortgage. We then went and drafted a purchase and sale agreement, which included how the second mortgage would operate. Both parties signed off on that deal. Then what happened was we go through the due diligence process, and we say, yeah, everything looks great. We're going to buy this property. We end up buying that property. What happened? Then we get to the physical inspection, and we decide to move forward to the financial inspection. That's when the bank gets involved. When we started dealing with the bank, one of the documents that they required us to send them was an operating agreement for the LLC that will own it and the purchase and sale agreement. Now, when we first got started with the bank, we hadn't even created the LLC yet. So we didn't even have an operating agreement to share with them. So that's a requirement of the bank, but that's going to be given to them before we close. Until I draft that document, we have nothing to give to them. But they did get the purchase and sale agreement because that's a document that's online, that's already been executed. Everybody's working off of it, and the bank wants to see it. And you always give them the real thing. Don't try to pull a fast one with your bank. The way you need to think about your bank is that they are your biggest investor. And with your biggest investor, do you really want to pull fast ones with them? No. They are, believe it or not, your bank. I mean, this should not be hard to believe. Your bank is your best friend in these deals. They are looking over your shoulder for you. So don't hide anything from your bank. So in that purchase and sale agreement are the terms for the second mortgage. Then the bank comes back and says, hey, you can't do this. Well, why can't we do this? Well, we won't give you the loan because of the way it's structured. Well, geez, why didn't you tell us this 30 days ago? Well, we just decided to read the purchase and sale agreement. And then you say, okay, well, how do we solve this problem? Well, because you haven't set up the LLC yet, you can then go back and restructure it. And you can set up a structure within the LLC so that you solve this particular problem. Now, and this is something that I teach in my due diligence seminar. I'm not going to get into it all that much right now. One of the rules that I pound into your head is always remain in control of the deal. You have to structure the purchase and sale agreement offer for the second mortgage in such a way that you don't have to go back to the seller, hat in hand, and ask them to revise the terms of the purchase and sale agreement because your bank came back and changed the terms. You have to structure the purchase and sale agreement in such a way that you left yourself that out and you told the seller, hey, I might need to come back and restructure this, and you better be on board or my money doesn't go hard. And that's what we teach in the due diligence seminar, okay? So we always make sure that you're in control of the deal. So when you finalize it with the seller as to how this second mortgage is going to look in the form of a particular class within the membership interest, You document it in the operating agreement. And yes, you give it to the bank, and they get to see exactly what type of company they are going to be dealing with. Okay? So everything gets disclosed. You don't hide anything. There are no secret seconds in this business. All right? Your bank is your best partner. You want to make sure you're doing it correctly. And if you negotiate correctly, and if you always remain in control of the deal, which is what we teach, this will not be a problem. You'll be able to solve this problem very, very easily. Okay, Mike? Hopefully that has solved that particular problem for you. Now, if anybody has any other questions, make sure I see Donald has his hand up. Donald, you always have your hand up, and every time I go to call on you, you say, sorry, I didn't mean to have my hand up. But if you have a question, Donald, type it in the box. I'll tell you what, Donald, I'm going to unmute you just in the event that you can't type into the box. And I'm going to unmute you, so if you have a question, you're going to be open up to everybody. And if you're not okay with that, just say so, and I will mute you back up to give you privacy. Okay, so Donald, you are coming off mute. Donald, can you hear me? Donald, can you hear me? Okay, maybe not. Okay, Donald, I'm going to mute you again. If you need something, just, oh, Donald's got a question. Let me see. Donald, okay, I'm sorry. Okay, Donald. Yeah, I don't know what it is. Donald, I have such technical difficulties with Donald, and I apologize, Donald. I'm working on them. Okay, all right, Ron Wilson has two questions. He asked the questions, are there any examples of investor packages for download? Yeah, you know what, Rob, I got to tell you, I got a couple of good ones. I got three good ones. They're actually on the second month of the private money tutorial. There are three handouts. There's the small multifamily, the medium multifamily, and the large multifamily offering package that you can take a look at. They're all in Word form, so you can manipulate them, you can modify them, you can edit them as you see fit, okay? And of course, yeah, there's some of them that have pictures of me and other members, other partners that I had throughout the years, so you definitely want to take those off as well. So yes, it's when you are in the program 2 months, you have access to the private money tutorial, the second month of the private money tutorial, and then there are three handouts in there for offering packages depending on the size of the property. They're really good stuff. Now let me just say something for the record. I got an email from one of the students this morning where he said he had trouble downloading those handouts. We're trying to figure out why he could not get to them. His level of membership should have allowed him access to that. We're trying to figure that out right now, and then we'll get that fixed. But if that happens to you, just send me an email, and I will send you the links to download those three forms. Hopefully that will solve your problem. So yes, Rob, that is available to you in the third month of membership. Let's see, lots of questions coming in right now. All right, now another question is, what kind of money can we make on a typical 100 to 150 unit, $3 to $4 million stable deal? There's no way that I can answer that. There's just so many moving parts to that equation. Acquisition costs, how much of a percentage ownership you own in the property. You know, I typically use in the Shark Tank weekends, I give people some rules of thumb in order to calculate how many units they need to own in order to achieve their multifamily objectives. I tell you what, Rob, you asked this question. Send us an email at info@multifamilyinvestingacademy.com, and we'll try to answer that for you offline. I think we might have something in the form of a recording or a PowerPoint presentation that you can see exactly how that works and how you're able to calculate it. But remember, it's going to be a more of an art than it is a science, because there are so many moving parts to that particular answer to that question. I'm not trying to avoid it whatsoever. All right, Bob says, I underwrite a deal where the cap rate is less than 7%, but the cash on cash is 11%, and the internal rate of return is high teens. Why such a low cap rate? Which numbers do we focus on? All right, well, you know, remember the cap rate is a function of the NOI over the purchase price. So the internal rate of return is a function based upon how well you structure the deal. Now, the internal rate of return goes to how much money you have to put into the deal. The calculation of the cap rate has nothing to do with that number. So you're really talking kind of apples and oranges. One goes to how well you structure the deal, and the other one goes towards really the valuation of the property, how solid of a deal the property is, how the quality of the asset, so to speak. So how can you have a lower cap rate and high teens internal rate of return? Absolutely no problem. That could definitely happen. It all depends upon the high cash on cash return goes towards the low money into the deal, and the lower cap rate goes towards the high NOI and a low purchase price. So you've got a bunch of different variables moving around there that don't necessarily tie together. So that's why when I talk to when a broker asks me what my requirements for a deal are, I never mention cap rate. And I never mention cap rate because based upon the other criteria that I give him, that criteria should equate into a particular cap rate in that marketplace. So I do not want to limit myself with telling him what particular cap rate I'm looking for if the deal is one that meets all the other criteria. So I never use the cap rate to a broker when I'm trying to negotiate, or trying to find property. I also never tell the broker the cash on cash return that I'm looking for. And the answer to that is because it's none of his business. I'm not going to tell him what my investors need for a cash on cash return. The cash on cash return is based upon how well I negotiate the deal with the seller, not with anything the broker has done. So I never mention cash on cash return to a broker. All right, hopefully that answers that question as well. And I'm sure Bob is going to let me know whether it does or not. Okay, I've heard a few versions of the LLC, for this being LLC partnership with a minority member at another LLC C Corp. I'm supposing the partnership would be me as a member of a new series LLC to manage the structure you just described. Does that make sense? Well, it does not. That does not make sense, Vance. I'll tell you. Try it again, and then let me see if I come back to. I'll see if I can come up with see if I can come up. Okay. Oh, Al. Okay. All right. Thanks, Vance. Let me talk about that in just a second. I'll come back to that in just a moment. Sam asks, when does the course talk in depth about property management? It talks in depth about property management after the offers, where we teach you how to make offers, how to draft letters of intent, and how to put together purchase and sale agreements. That's really down the road a little bit, Sam. But we also talk about it extensively in the due diligence weekend. I'd love to see you, Sam, at the due diligence weekend. I'm not sitting here trying to sell you on it. I think you all should go. If you're serious about this business, the due diligence weekend is a great training course. I'm going to be sending out another blast email to all members of the Masterclass Elite program to have you sign up, because seats are limited. I'm about 50% full right now. But I'd love to have you there, but we talk about property management more in depth there. Right now, during this particular class, we're trying to teach you how to properly evaluate deals, find deals, make offers on deals, get deals under contract. Now, when you start to go through the due diligence process, that's when you're going to really start to look at property management companies and how they can help you through the due diligence process and how you can work with them after ownership. So that's typically when we start talking about property management in more detail. But, Sam, if there's something in particular that you want to talk about with property management, send us an email at info@multifamilyinvestmentacademy.com, and I will make sure that it gets taken care of. I want to make sure you feel comfortable with that. Okay, let's see here. Okay, just to clarify, guys, to this slide, when you say series, do you mean these separate entities under the parent entity? Yeah, the whole thing is called a series LLC, and then what we call is the parent LLC, and different states and different lawyers are calling those entities below the parent LLC different things. they're called sub-LLCs or series LLCs or sister LLCs. So that is something you've got to feel comfortable about, or when you get into a particular series LLC and you choose which state you're doing business in, you want to make sure that you're using the right terminology based upon how that state calls the sub-LLCs. Now, one of the questions that the student asked me is, you know, can you hire me to draft the operating agreement? Yeah, you can, but I'm really not looking to take on legal work for my masterclass students. I will help you out every step of the way as more of a consultant, but I will not take on a legal work. And the reason being is I'm very, very careful with making sure that I don't provide legal services in a jurisdiction that I'm not licensed in. I just don't even want to go down that road with any other bar council offices. That's just not what I'm about. And I always recommend, especially in different states, you've really got to get the proper operating agreements for that state so that you do it correctly. And guys and women, please don't cut corners. You're looking to raise private money, other people's retirement money. Don't do it wrong. Make sure that you cross all your T's and you dot all your I's and you do it correctly. And that means making sure that you have competent counsel in those areas that you need to set up that operating agreement so that it works, so that you've covered your tail. Remember, this can come back at you if you don't do it correctly. So always make sure that you do things correctly, and that includes hiring attorneys in the jurisdiction that you need those documents drafted in, and making sure that you get the right operating agreement for the series LLC in that jurisdiction. All right, don't fool around. Okay, let's see. What is modified internal rate of return before tax? And Sam, okay, what is net present value before tax? Okay, Sam, I think you're grabbing these questions off of the cash flow analyzer. Sam, well, let me ask you this. Please send over the if you're getting this off the cash flow analyzer, please, and you're doing it based upon a particular deal that you're looking at, send me the file for the cash flow analyzer and ask me these questions in the email. I want to make sure, I need to see how you set up the input screen so that I can answer these questions correctly. All right, so send me over the file, and then I'll take a look at it for you probably by tomorrow, and I'll make sure that I get these questions answered for you correctly. Because some of the things like net present value, that takes into consideration the sales expenses as well. So I want to see how you set that up on the deal. Now, getting back to Vance's question, and now Vance just qualified his question by letting me know that it's an Al-Aiello structure. For those of you that don't know, Al-Aiello is an accountant who is very good, and he sells a very good program. The issue that I've had with some of Al's documents has to do with his operating agreement. One of the things that he does in his operating agreement is he lists out all the categories of jobs that take place in the owning of property. And then he provides a certain percentage structure to that. The whole idea is that, and this is something you all should understand, because this gets back to partnerships and how, I've had nothing but problems with certain partnerships. And I see this happen all the time. People come to me, oh, I found this great guy, and he really wants to work with me, and he says he's going to put up all this money, and for all this money he wants 50% ownership and all this other stuff. And the problem is that the new investors don't quite understand what it takes to own and operate a property. So when someone comes along and says, hey, I will put up the money, but you and I are going to be 50-50 owners in it, and you'll run everything on the property. I'm just going to give you the money and sit back and watch you do the work. As a new investor who's hungry for the deal and hungry for that private money, this sounds like manna from heaven. Like you just hung the moon, like this is a great deal and you should just grab this. And I'm here to tell you that 50% ownership for all of the equity being raised is a very rich deal. One guy getting that for just 1 day's worth of work, writing a check, and now he owns 50% of the deal that you have to work on for the next 5 years. Because to own and operate a multifamily property takes work. I'm not going to sit here and tell you, you just put your feet up on an ottoman and put everything on remote control like some other guru does. It takes work. You are owning and operating a business, and you're going to watch that business every single day for the next 5 to 7 years. And you've just given away half of the deal to somebody that you'll never even speak to again until you sell this property. You got to ask yourself the question, is that a good deal? And now what Al Aiello did in his operating agreement is he tried to break down all the different rules, all the different steps involved with ownership, and provide a percentage to that stage, and then determine what each person should really be entitled to. And early on, I represented a client in I was their lawyer, and we had a problem with the operating agreement that Al had structured because it didn't make any sense in the operations of that particular property. So that's something that you need to think about when you're looking at those deals. And I'll tell you something, folks. As members of the master class, if you get to this level where you're trying to figure out the operating agreement, shoot me an email, get me on the phone, let's talk about it, and I will make it very, very clear to you. And it's going to be a tough, long conversation. I can guarantee you that right now. But I want you to make sure that you do this correctly at the very beginning, so you don't have any problems going down the road. And that's what I'm here for. So let me, having said that, let me go back to Vance's question. I've heard a few versions of the LLC, this being an LLC partnership with a minority member as another LLC or C Corp. I'm supposing the partnership would be a member of a new. I'm still not quite getting it, Vance. And I want to make sure that you once again you get your nomenclature correct, because you say right in the beginning different versions of the LLC for this being LLC partnership. I don't. There is no such thing as an LLC partnership. There are no partners in an LLC. There are members in an LLC. So if you want to ask me that offline, I'll be more than happy to discuss that with you. So, okay, Mike, is not only that, but if you give away half of the deal and you have a deadlock with your investors, you're inviting trouble. Yeah, okay. So what Mike is saying, okay, thanks, man. So what Mike is saying is that he says not only is what I just described, where a 50-50 deal structure with the cash investor is a problem, but he says, but if you give away half of the deal and you have a deadlock with your investor, you're inviting trouble. So what he's saying here is if you set up the operating agreement such that all decisions are made on a 50-50 basis, yeah, you got a problem. And this guy's nowhere to be found. And you're going to make a decision. And according to the operating agreement, the two of you need a consensus to determine what's going to happen with this property. Maybe to determine if the property gets sold or not. So what you want to make sure, and this is something we were talking about before, remember how I said that we have different classes or different ways of setting up the structure for control, not just for the investment, but for the control? That's something else you put into the class structure. Class A, that's you. You're Class A. What do you get? You get X percentage membership interest. Well, how much does that cost you? Well, nothing in the form of cash, because this is going to be what we call a no money down deal for you. Doesn't mean that the deal is a no money down deal. It just means that you are going to get a percentage interest in this property for no money down. Okay? So now you put in, now you know what you're getting in the form of equity. But what do you get in the form of control? Well, I want to control the whole deal. Okay. What about these cash investors? Well, man, I don't want to bother with them. I want to run this thing myself. Well, how are we going to take care of them? Well, we'll take care of them in the form of distributions. But they're not involved in the day-to-day operation of the property. Oh, okay, you're doing everything? I'm doing everything. Okay, great. So let's structure this so that there's a Class A You're Class A, you get X percentage membership interest, and you have 100% of the voting rights. And then Class B gets the remaining ownership structure, remaining membership interest, and no voting rights. So in this particular case, who controls? Well, you do. But remember how let me go back here for just a second, just to give you a legal, remember how we said here, check out Delaware. They put, the Delaware Limited Liability Company Act. Every state pretty much now has a Limited Liability Company Act. And what that means is that you're entitled to draft an operating agreement, and your operating agreement can say a whole bunch of different things, but it still has to comply with the Act. And if it's in violation of the Act trumps it. And one of those things that the Act says is that if you self-deal, if you commit fraud and waste and abuse, if you do not treat the other members correctly, you can lose those voting rights, and those other non-voting members can come in and kick you out. And I'm being kind of graphic here, but you have to read the Act. In other words, you can say certain things in the operating agreement, but if it violates public policy, you're going to lose. And violating public policy would be you as the Class A member committing fraud, waste, abuse, and treating the other members in a very, bad faith manner. So that's something you need to always keep in mind when you're putting these things together and giving yourself total control. It says you're giving yourself total control, but the government is looking over your shoulder and making sure that you perform correctly. Okay. Let's see here. Let's see. Okay, there's a question. Let's see. Mike said it. That's exactly right. Okay, Mike, good. I appreciate that. I think Bob was trying to tell me that I'm a gentleman. Okay, so that's the last question I have. If anybody has any other questions, please feel free to send them here, or if you have anything else, just info@multifamilyinvestingacademy.com. I will get to them tomorrow. I will, I'm off to, and then just, of course, I lose the string. And there we go. Okay. Yeah, so that should, there we go. That should pretty much do it for this particular call. Hopefully that answers all of your questions. Hopefully this was helpful. I'm going to have this particular reporting encoded, and it'll be up on the membership site hopefully by no later than tomorrow. Hey, guys, great questions. I so appreciate your questions. As always, I'm here to help you. I want to see you succeed at this business, and the only thing you need to be doing is making offers. If you have any questions about making offers, always just contact me. That's what I'm here for. So, hey, everybody, have a great night. I appreciate your time, and we'll talk again in 2 weeks. Thanks.